Hello friends, welcome to Inside Psychian Initiative. In this video, we are going to discuss about Aligarh Muslim University. You know that there is a case pending in Supreme Court whether Aligarh Muslim University recognized under minority institution or not. Regarding this, we will discuss in this video. Actually, this case is very, having very long history. This has been in legal battle since 1967. Let's see what Supreme Court will give the judgment. But meanwhile, let us try to understand what is this dispute about and what are the constitutional elements present in this and what are the legal intricacies. Now, without any further delay, first let us try to understand video components. In this video, we will try to understand why this is in news, that means the context of this particular topic. Then Aligarh Muslim University and the backdrop of this, like who established this and what was the main intention of this, the intention behind the establishment of this university. Sir Syed Ahmad Khan, what is the intention that and how he contributed to the upliftment of the minorities, we will discuss. Then minorities in India, who will recognize a particular religion as a minority, whether that recognition will be only at national level or minority recognition can be in state level as well, we will see. And some of the constitutional provisions such as Article 30 and Article 30 clause 1, clause 2 both. Then Article 350 subclause B, we will discuss 350B. Then some of the Supreme Court judgment related to this, and finally minority educational institutions and what the provisions related to that. So this is how, these are the topics we are going to discuss. Now first, let me help you out in terms of syllabus mapping. This related to Gender Studies paper 2, Polity and Governance. First, why it is in news? Let me give the context. Later, I will explain the concept behind this. First, this context is about now the seven judge bench, which including the CJI, they are examining whether the Aligarh Muslim University, whether it can be given the minority status or not. In this regarding, they are reviewing the judgment given in 1967 as well as the judgment given by Allahabad High Court in 2006 as well. Actually, these two judgments, they declined to give minority education status to Aligarh Muslim University. Now, Supreme Court is going to revisit those two judgments. So now let's see the concept behind this. First, Aligarh Muslim University, the intention behind establishing this university is about uplifting of Muslim community in terms of providing Western education and encouraging them towards more a research oriented approach. First, it was started in 1875. It was started in 1875 as Anglo-Muhammadan Oriental Institute, okay, Anglo-Muhammadan Oriental College. It was established, okay. Later, in 1920, it was converted as university. It was converted as university by then government. Here you have to understand the legal point, that is, it was neither established by minority group nor maintained by the minority group. But in the backdrop of establishing this university, minorities put some interest because they wanted the degrees offering by the university, they should be accepted by the government. For that, government should recognize them. For that, their effort was there. But according to government view, this was neither established by the minorities nor administrating by the minorities. According to this Universities Act 1920, AMU Act was made. Aligarh Muslim University Act was made. Later, there were certain amendments were done in 1951 and 1965. So certain amendments to AMI, amendments to Aligarh Muslim University. After this, then what happened? These amendments then questioned in 1967, very landmark judgment regarding this university. In 1967, then Supreme Court observed that Aligarh Muslim University, it don't comes under minority institution. Okay, of course, this created a lot of displeasure, okay, among the Muslim communities. Here, the Supreme Court judgment. In this judgment, they declared that AMU is not minority institution. Aligarh Muslim University is not minority institution. That is the judgment in 1967. Then this, so to overcome this defect, in 1981, AMU Act was amended. AMU Act amended in such a manner that, so this amendment clearly explicitly saying that AMU is a minority institution. Then this was challenged, okay, in Allahabad High Court in 2006. Allahabad High Court categorically mentioned that Allahabad High Court also supported the Supreme Court previous judgment in 1967. It's categorically declared that this AMU is not minority institutions, not minority institution. Then this Allahabad High Court judgment, it was challenged in Supreme Court in 2019. It was challenged, of course, in between. So in 2006 itself it was challenged. Okay, later government withdrawn from that petition. Then in 2019 Supreme Court decided that they would like to forward this case to the higher bench strength. That means this case was examined by the bench which consists of 3 judges. It forwarded to the higher bench strength. Now in 2024 the bench strength with 7 judges bench. Now it is examining this issue. So this is the overview regarding the legal related aspects of Aligarh Muslim University. In this entire thing, why they are trying for the minority institution status, that you have to understand. Constitution provided certain safeguards to minority institutions. Okay, Constitution provided these safeguards under Article 30, Clause 1, Clause 2. Article 30, Clause 1, Clause 2. Under that, Constitution provided certain safeguards. Okay, let's see. Article 30, Clause 1 and Article 30, Clause 2. Article 30 is about the right to establish minority education institutions. Right to establish minority education institutions. This is the Article 30, Clause 1, and Article 30, Clause 2 is explicitly saying that no discrimination in terms of the no discrimination towards minority institutions. This we have to understand. And one more thing, even for the promotion of the educational rights of minorities, Article 350 also. Article 350, it is having 2 clauses, Article 350A and Article 350B. Article 350A is about promoting education in mother tongue language to minority, to linguistic minority, okay, in any respective states. It is about providing education to the minority in their mother tongue language. This is that. And Article 350B is about special officer for linguistic minorities. These are the constitutional provisions. And according to Article 30, one more thing you have to remember, that is, when government is acquiring any property from minority institution, then government has to provide suitable compensation as well. That means here the compensation itself is provided in Article 30, unlike the compensation related to Hindu religion. In the Hindu religion, the compensation related thing mentioned in the Article 300A, that is the right to property, that is the legal right. But for the minority institutions, the right to property is a constitutional right under Article 30. That thing also you have to keep in mind. Now, students, who will declare a particular religion as a minority or not? Okay, whether the central government or state government? Answer to me. And one more thing is, in India, how many minority religions are there? Okay, put your answer in the comment section. How many minority religions are there? Put your answer. Okay. Next, the origin. Muhammadan Anglo-Oriental College. Okay, it was established in 1875 by Syed Ahmad Khan. The objective is to overcome the educational backwardness and prepare the Islamic community for government services by giving Western education and women education and Islamic theology. It was established later. It promoted to be university under University Act 1920. And now it is a public central university in Aligarh, Uttar Pradesh. Minorities in India. The subject of identification of minorities, it comes under the concurrent list. That means a particular religion can be identified as a minority or not in the national level by the central government. In the state level, respective states can identify a particular religion as a minority or not. Actually, in Arunachal Pradesh, Hindus were allowed to be identified as minorities as well, because they are the majority community is Christian community. Regarding that, Supreme Court observed that the minority status is a state specific. One religion in particular state which is minority may not be minority in the other religion, that we have to understand. Who decide the minority status in India? Central government, according to the section 2 clause C of the National Commission for Minority Act 1992. This is at the national level. So far 6 religions they given the status of minority, that is Muslims, Christians, Sikhs, Buddhists, Jains and Parsis. Actually Jains got minority status in 2014. However, in 2022 the central government informed Supreme Court that states can also given minority status to religions based on the numbers. Article 29 deals with the protection of cultural rights of minorities. Article 30 deals with the educational rights of minorities. Article 350B it deals with the special officer, special officer for linguistic minorities. This was inserted by 7th Constitution Amendment Act 1956. Next, TMA Pai case. In this case, Supreme Court observed that minority status is a state specific, like we discussed. Okay, it is only related at the state level. So, in a state, if a particular religion is less in number, even though that number is high in the other state, still that religion can be identified as minority status. In Amdar case, in this case, minority, whether they are linguistic minority or religious minority, it is based on the demography of a state. And in this case, Supreme Court also observed that minority institutions are mainly broadly 3 categories. Some minority institutions, they may want only recognition from government, not funding. Some may require only funding, not recognition. Some may require both aid as well as a recognition. There are different types. Bal Patil case also supported the same argument of Supreme Court, same judgment of the Supreme Court, which was given in this TMA Pai case. Actually, TMA Pai case is a landmark judgment regarding the religious institutions, religious education institutions. Minority educational institutions in India. Okay, minority educational institutions. These are the educational institutions which are set up by the minorities, which are set up by minority groups. Article 30, like we discussed earlier, it is giving educational rights of minorities. In case when property is taken over by the state, due compensation has to be provided. That means giving compensation to the minority institutions, it is a right protected under fundamental rights. Legal provisions. National Commission for Minority Education Institutions Act. Okay, it is safeguarding the educational rights of minorities under Article 30 Clause 1. Actually, this National Commission for Minorities, it is a quasi-judicial body, and in certain cases it can act as a civil court as well. Present case. The present case started from 1967. 1967 in the S. Aziz Basha and other versus Union of India. In this case, Supreme Court clarified that AMU is not a minority institution because it was not set up by minority group and it was not administered by minority group as well. To overcome that, 1981 amendment was made. This amendment nullified the Supreme Court judgment and it reinstated that AMU will be the minority institution. Later that was challenged in 2006. Okay, in 2005 AMU introduced a policy. According to that policy, 50% of the seats in AMU in the post-graduation PG medical seats reserved to Islamic community only. That was challenged and Allahabad court again reaffirmed that it cannot be considered as minority institution and it nullified the 1981 Act. Then it challenged in 2006 in Supreme Court and 2016 government withdrawn, and in 2019 Supreme Court referred this case to larger bench. So this is about the AMU case details. Now let's see yesterday's video MCQ question. Widespread resistance of malaria parasite to drugs like chloroquine has prompted attempt to develop malarial vaccine to combat malaria. What is the difficulty in developing an effective malarial vaccine? What is the difficulty? Difficulty is man does not develop immunity to malaria during natural infection. This is the main issue, because if you develop the natural immunity, then and the next time when that same infected, then obviously your body will react. Otherwise, if no natural immunity is developed in the body, that means this vaccine also cannot work. That is the main issue here. Okay. Next, today's video question: which fundamental rights cannot be suspended even during the emergency as well? Next main question: discuss the problems of religious minorities in India. What are the main issues? Now, as we reach to the end of this video, let us do the quick revision. In this particular video, we discussed about the Aligarh Muslim University minority status case. So, as a part of that, we discussed the legal timelines, then constitutional provisions related to minority institutions, and some of the landmark Supreme Court judgments. So, this is a detailed analysis regarding the AMU minority status issue. Thank you.